Hi everyone, this is Catherine Schomburger, and before I get started, I just want to let you guys know that me and my partner Tanisha are going to be doing our presentation a little different because we weren't able to meet in a timely manner. So this is basically part one of the presentation, and she's going to be doing part two of the presentation. So our case analysis was Snead v. Board of Professional Responsibility. And the factual summary is Michael H. Snead has been a licensed Tennessee lawyer since 1985. However, since May of 1993, Snead has violated countless ethical rules and been reported and disciplined for each rule that he's violated. Among many of those complaints were Vicky Berry and Enrique Lopez, who reported Snead for failing to file suits within the statute of limitations or representing other clients that had a conflict of interest with previous clients. The rules that were broken for Michael Snead's case that we could use, because we were only able to use rules from weeks 1 through 4. The first rule is 1.9 and B, duties to former clients, which involves the case with Enrique Lopez. And a little history about that case was Mr. Snead represented Mr. Enrique Lopez in a claim of seized money. However, Mr. Snead didn't inform Mr. Lopez of two other individuals who were also involved in the same incident. He didn't inform Mr. Lopez that he was representing two other clients that had the same situation, the same incident happened to them, which basically created a conflict of interest. And Mr. Enrique Lopez reported Mr. Snead and was given a disciplinary action by the Board of Professional Responsibility. The next rule is Rule 1.16, which is declining or terminating representation. This rule comes from when Mr. Henry Snead was discharged from practicing law. He was basically put on probation. However, he was still practicing law, still giving people legal advice, which he wasn't supposed to be doing, and he wasn't informing his new incoming clients that he was discharged from practicing law. And so those new clients were paying him for fees and getting everything done for their cases, but he wasn't getting it done because he couldn't really practice law because he was discharged for a period of time. The next rule is 5.3, which is responsibilities regarding non-lawyer assistants. And this goes to Elliot Osmond's case, where Mr. Snead engaged in an unauthorized practice of law with a woman named Carmen Seja and her business Seja Enterprises. I hope I said her name correctly. She basically did all the legal research, did all the work, the paperwork that goes into filing claims and lawsuits and things of that nature. However, Mr. Snead was basically the face of the company. He would go to court and he would speak on behalf of Mrs. Seja. He would pretend as if he were the lawyer working the case the entire time, or if the clients needed to meet with someone involved with Mrs. Seja's Enterprises, he would be the person that they would meet. So basically, he was there just for a showing. Although Mrs. Carmen Seja did all the hard work and all the research and everything like that, and she doing all this, she wasn't a lawyer herself, so that made it an authorized practice of law, which is a criminal charge against both her and Mr. Snead. Now I'm going to attempt to go back and show you guys the rules and what they say. And this is rule 5.3, responsibilities regarding non-lawyer assistance. And I was able to get C1, a lawyer shall be responsible for conduct of a non-lawyer that would be a violation of the rules of professional conduct if engaged in by a lawyer, if the lawyer orders or with knowledge of the specific conduct ratifies the conduct involved, or the lawyer is a partner or has comparable managerial authority in the law firm in which the non-lawyer is employed, or has direct supervisory authority over the non-lawyer and knows of the non-lawyer's conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Wow, I can't talk today. And now I'm going to go ahead and show 1.16. Let's see. If I can get to it without going crazy. Okay, and here is Rule 1.16, declining or terminating representation. And I was able to point out, if I can get it, there it is. 3, except as stated in paragraph C, a lawyer shall not represent a client or where representation has commenced, shall withdraw from the representation if the client has used the lawyer's services to perpetrate a crime or fraud. And as you can see, I kind of highlighted it for you. Hope you guys can see that, where it states the client has used the lawyer's services to perpetrate a crime or fraud for the Elliot Osment matter, which Mr. Snead was reported for. The next rule I'm going to point out is Rule 1.9. Give me 1 second. I should have used the online version instead of the PDF version, but here we are. So I'm just going to continue going. And here we go. Rule 1.9, duties to former clients. And for this rule, I was able to use A and B. A lawyer who has formerly represented the client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent confirmed in writing. Unless the former client gives informed consent confirmed in writing, a lawyer shall not knowingly represent a person in the same or a substantially related matter in which a firm with which the lawyer formerly was associated had previously represented a client. And this Rule 1.9 refers to the Enrique Lopez matter, where Mr. Snead represented 2 other individuals who had the same incident, same problem as Mr. Enrique Lopez, which caused a conflict of interest. And Mr. Enrique Lopez was not aware of it until after the fact. And that is the end of the first half of the presentation. Tanisha will go on and add her second half to the presentation, which goes on to more of the ethical issues that happened in this case. Thank you.